situations is to simply respect your coworkers. Respect is fundamental to a functioning society, and behaviors that escalate to the level of harassment show great disrespect to the victim. No one purposely harasses someone that he or she respects, although there have been cases where individuals have falsely claimed harassment due to oversensitivity. Most adults understand the meaning of harassment opposed to teasing, annoying, or irritating conduct. Keep this in mind when you are determining if you are experiencing true harassment or simply dealing with a coworker that has an annoying personality. Also, looking at one's own intentions or feeling toward coworkers is a good way to determine if you are risking behavior that could be perceived as harassment or discrimination by others. The next session is called Humor at Work. An important principle to remember about humor is that most people enjoy good humor, but the truth is all humor is not good. The timely and appropriate use of humor can be an asset in the workplace. It can help acclimate new employees into an existing department, release tension, and make people feel more comfortable. Many times we use humor to alleviate tension in the work environment. It makes us suddenly feel connected to the others involved and lets us in on situations common to those in the department or team. It can be used to create a sense of us among teams. In the same way, distasteful and inappropriate humor risks causing others to feel belittled, humiliated, and even attacked. Using this type of humor is risky as it can lead to being perceived as discriminatory or abusive. Inappropriate humor has the opposite effect of well-timed humor. Although it can make some of the group feel like they are part of the quote-unquote in crowd, it singles out those who are the targets of the distasteful humor, causing them to feel humiliated and alienated. This type of humor is incredibly destructive to a team or department and will always eventually lead to claims of discrimination, or if not that, high absenteeism and turnover in the company. Favoritism. Favoritism is when a manager gives benefits to employees based only on who they like, instead of looking at which employees are doing the best job for the company. Although favoritism in itself is not typically illegal, managing through favoritism versus fairness is extremely damaging to workplace dynamics. It hurts the morale of the employees, reduces productivity, and increases turnover. Favoritism can be illegal if the manager's favoritism is based on the following characteristics: a protected characteristic such as age, gender, race, etc., membership in a union or specific group, and willingness to put up with or agree to sexual advances or favors. Intent versus impact. Another factor that is important for employees to understand when it comes to harassment is the difference between intent and impact. It is not the intent, but it is the perception and impact which determines whether or not an act is harassment. The impact of our actions far outweighs the intent of our actions. In a situation where you are dealing with conduct that may potentially result in a sexual harassment or abusive conduct complaint, what you intended doesn't matter. The only thing that matters is the impact of your actions on your work environment or on the recipient of your actions. To the perpetrator, their display of behavior may or may not be intended to be sexual or discriminatory. However, the recipient of the message may find it offensive. One example of this is a person who enjoys practical jokes. Because of this, he believes everyone else must also enjoy them and consistently plays them on his coworkers. Although this person's motivation comes from trying to treat others in the way he enjoys being treated, Not everyone enjoys practical jokes being played on them, and some may even feel harassed, embarrassed, singled out, or even humiliated by these jokes. Severity and duration. Although there are a few instances where one act can be considered severe enough to cause a hostile work environment, most of the time the issue is created by a variety of incidents over time. The severe or pervasive requirement was originally implemented to filter out complaints about the regular irritations of the workplace, including the occasional use of offensive language, gender-related jokes, and occasional teasing. When a case is brought to court, the entire situation must be considered as a whole. The severity of the actions have to be looked at in combination with how long the actions were taking place, which is duration. Severity is the harshness, intensity, or strictness of the behavior or punishment, and duration is the length of time something continues to exist. In addition to severity and duration, the court will implement the reasonable person test, which was just discussed. The systems that accept complaints of workplace harassment must ensure that a true harassment claim is being brought before them in order to keep a balance between the valid claims of harassment and situations that may simply be frustrating or annoying, but are not necessarily harassment. There is no definition of how severe an incident needs to be in order to qualify as harassment, although typically physical actions are considered more severe than verbal actions. Also, there is no predetermined number of harassing incidents or a specific period of time during which they occur that suddenly creates a hostile work environment. Typically, more incidents within a shorter period of time create a much stronger case. Types of harassment in the workplace. There are two basic types of harassment that occur in the workplace: sexual harassment and abusive conduct, also called discrimination. In order for sexual harassment to become illegal or unlawful, the harassment must meet certain conditions. Similar to the EEOC's stance on general harassment, the conduct must include unwelcome sexual advances, requests for sexual favors, and other sexually oriented verbal or physical behavior, which becomes sexual harassment when submission to the conduct is explicitly or implicitly a condition of employment, the victim's refusal or acceptance of the behavior influences decisions concerning their employment, or the conduct unreasonably interferes with the victim's work performance or creates an intimidating, hostile, or offensive work environment. As mentioned before, a key part of the definition of harassment, including sexual harassment, is the concept of the conduct being unwelcome. Unwelcome actions or communication of a sexual nature is prohibited by law. Welcome or invited actions or words are not unlawful. Romantic interaction between consenting people at work may be offensive to observers, but it is not sexual harassment. We will now go over some examples of what would be considered sexual harassment. Sexual harassment includes many different types of behaviors. These could be including unwanted sexual looks, gestures, sexual teasing, jokes, remarks, or questions, referring to others by pet names, including girl, hunk, doll, babe, or honey, sexual comments about a person's clothing, anatomy, or looks, touching an employee's clothing, hair, or body, hugging, kissing, patting, or stroking, and actual or attempted rape or sexual assault. Take a moment to look over these additional actions that could be considered sexual harassment.